Good morning. I just started the recording. Welcome to How to Build a Rock Solid IP Portfolio, hosted by our very own Idea to IPO. I would like to start by thanking them for putting on this webinar and for the many other webinars we've done together. My name is Stephen Colby. I am a patent attorney and a US California attorney. I am not an attorney of any other country. So if you are coming from South Africa or Singapore, please remember that I'm talking about US law here, and California law specifically. Uh, that's it. So I am a partner at a law firm called Ramon Law. We are one of the largest semi-virtual law firms, meaning that we do have some offices, but they're mostly conference rooms and admins. Most of the attorneys work from their home office, including me. I am either in Reno, Nevada, or San Francisco, California, mostly Reno, but I work primarily with Silicon Valley early stage startups. That's my niche, and I like doing that a lot. Right? I get a lot of joy out of helping people when they're just a couple of founders and they want to get started off. And being a patent attorney, I'm the type of patent attorney that does what's called patent prosecution, right? This means I get patents issued by the patent office. I do some patent litigation, but that's probably less, roughly 5% of my practice. So I am familiar and I have had done a number of litigations over the years, but primarily I'm a patent prosecutor. I like working with early stage startups because I can be a big fish in their little pond. Very often I'm one of the first attorneys they talk to when they've decided they're going to do some venture or have come together with some new technology and are trying to figure out what to do with it. I have been the CEO of several funded startups in the past. No great exits at this point, but during the 1990s, I spent most of the 90s as a CTO of a chemical instrument company before going to work for a law firm in 2000. So I've been doing the law side of this for 25 years from within a law firm, and probably 30 plus years as an inventor, right? One more thing to say. Listening to this webinar does not automatically make you my client, right? That requires a contractual agreement, an engagement letter under the rules of the state of California. I will, at the end of this seminar, be answering questions. Please put your questions in either the chat or the Q&A tab if that's available. Yeah, put them in the chat. After my webinar is over, I will take about an hour blabbling to you speaking, and then I will go through the webinar chat looking for questions. I see there's one already, and IP law is not different from state to state, not the IP part of it, but some of the things like assignments of inventions to companies, those fall under state law, or employee duties to assign to a company. That can vary state by state. It's a lot different in California than it is, for example, in Florida. Okay, I'm going to ignore the chat now. I can see you're there, but I will go back to the questions once I get done. So the first question, why? Wait, where's my little button? Let's just hit an arrow. That didn't work. There we go. All right. Why would you do this? All right. You and your co-founders are a small cash-strapped company just trying to get off. You haven't raised money yet. You argue about who's going to pay for the coffee at Starbucks. This is the early days. Why would you consider, oh, we're going to put thousands of dollars into an IP portfolio? Well, it's to increase the value of your company. That is the number one reason. It's not because you're going to fight off the world or your patents are going to make such a big difference that it's usually going to be the thing that makes you successful or not. It's because you want to increase the value of your company. If I do my job right, then every time you raise money, I pay for myself many times over, right? And I have seen cases where there have been some pretty spectacular, fantastic exits. And while certainly the IP portfolio didn't make all the difference, it made a substantial difference in who in the value of the company on the exit, or even if there was an exit at all. Right? So the first question is, why to do this? And you're going to remember one thing out of this webinar. It's the purpose of IP for your company is to increase your valuation, right? So that the investors and the eventual acquirer, right, look at your company as being more valuable. So let's give an example. If I'm an acquirer and I'm looking at buying 3 possible startups in medical AI, let's say, one of the factors that might make a difference is which one has a good portfolio. Another factor that might make a difference is I'll be thinking, well, I could spend $10 million and put 100 engineers on this in 6 months and reproduce it all. Or I could buy this company for $300 million. Which is better? Well, the IP portfolio can make a difference in that calculation. Right? It can make a company decide to buy you instead of going into competition with you. Right? So that's the goal. That's why you're going to do it. So let's talk about a little bit about what you can get. All right. There's a bunch of different types of IP. I am biased. Yes, I admit it. I'm a patent attorney, so I deal primarily with patents, right? Sometimes trade secrets. Most of my clients eventually get trademarks and they have copyrighted material. But the primary value givers and the part where I really can contribute is on the patent side. I'm going to go through each of these a little bit right now. Copyright. Copyright is the type of thing that protects a book, the writing and language of a book. It can cover or a movie or a piece of art, right? Or source code. So copyright can cover source code. Copyright can cover your website. And I have had clients where somebody else has copied their website page by page, right? And I've gotten on the legal bandwagon and had them shut down. Okay. So copyright protects things like works of art, creative works, the layout, the image of something, the layout of your website and the words on your website. That's all copyright material. Now, copyright automatically applies, right? When you create something, there's a copyright in it, and that's initially with the creator, all right? And so for your website, it might be the web design company that you hire. Copyright can be enforced. You have to register it to enforce it. It's relatively easy to register. You can go to the Department of Commerce, the Library of Congress, and register copyrights. You can take images of your website and your text or snippets of your source code and copyright it at the Chamber of Commerce. There's a small fee, and it's relatively easy to do yourself. What you copyright will become public, right? So it's out there. You don't need to register a copyright until you're ready to enforce it. So the actual registrations that startups do are relatively far in between. Right? Trademarks. Trademarks, we know lots of hot trademarks. Coca-Cola, IKEA, right? All those things are big names, right? They're brands, they represent brands. It can be a product or a service. A trademark can be very useful. If you are a early stage AI company and you want to be on the Apple App Store, having a trademark that includes one word that's commonly searched and one word that makes you really distinctive might be very valuable to you to get bounced up in the search rankings, right? So trademarks on different types of company can be really useful. Trademarks don't automatically get created. You have to put them out there as a trademark. So I'm going to give you, here's another little free bit of advice. Put the name of your product or the name of your company or your tagline or whatever thing you're going to be using to represent your brand, your products and services. Put a little TM next to it, right? That gives you initial common law rights. You don't have to do anything else. Put a little TM and write down when you first used it on your website. Because somebody will someday ask you when you're actually applying for the trademark, when was the date of first use? And you'll be able to say, yes, it was a year and a half ago. We used it on our website. We used it on these flyers we sent out to investors all over the country or all over the world. we had a little TM there, and that gives you some initial rights in most countries. There's a few countries in the world where it's a first to file situation. China used to be, and it probably still is that way. But again, I'm not a Chinese attorney, so you have to ask somebody who specializes in that area. So trademarks, you can get away with a little TM when you first start. You don't need to put your precious dollars into trademark applications right away. But if you are a company that's going to be using your brand and your brand's going to have value, you definitely want to have that on your schedule of things to do in the first year or so, right? Is actually apply for a trademark. And they're relatively cheap. A few $1,000s should get you a trademark application. It's also something that should be done by an attorney because the exact language used in a trademark application can really dramatically affect the results you get and the value of the mark that you get, the scope. Right? Trade secrets, boom, they're free, pretty much almost free, right? Trade secrets is something that you think you're going to be able to keep secret and you actively keep other people from knowing. That's an important phrase there. You actually have to make some effort, right? And it's something that has value. Okay? So it could be a trained neural network. It could be a formula for how long you cook your semiconductors to degas them. It could be a mixture of order of chemical reactions that you do. All these things, or some algorithm that you keep in the background. All these things are potential trade secrets. Now, the things that startups often miss with trade secrets is the part about actively keeping it a secret, right? If you consider it a trade secret, but everybody in the company knows it, and it's available to any employee when they log into your computer system, then it's probably not as secure a trade secret as you think. You actually need to take steps, control who and who does not have access to it, right? Write the trade secret down. Keep a notebook of all your trade secrets, a one-page descriptor. If you're really good at what you're doing, you will have a program saying this trade secret, only the people in these positions, only on a need-to-know basis will people have access to it. And the trade secret could be pricing formulas or customer prospect lists, right? There's lots of things that can be trade secrets. And maybe every salesman isn't going to get access to the full database of all your customer prospects. Maybe the COO and the director of sales or marketing is going to have access to that. You're taking steps to limit who gets access to it. Even further, one of the things I advise clients to do is when somebody does get access to it, they have to sign a little piece of paper saying, yes, I understand that this trained AI, right, with all the weightings and so on, is a trade secret of the company, and I'm not going to share it with anybody else. And when they leave the company, they sign a piece of paper, or they're shown again the paper they signed originally to remind them that there was something that was a trade secret. I always feel sorry for the engineer who codes something up, some clever way of doing something. And then 5 years later is at another company and says, oh yeah, I did that before. How did I do it? Oh yeah. And he looks in his notes and pulls up the same algorithm. And how's he going to remember what that, his long past employee considered or didn't consider a trade secret? Maybe the CEO of that company thinks that algorithm is a trade secret. So if you write them down, you keep records of it, you make employees who get access to trade secrets very aware of what is and isn't a trade secret, then you are much more likely to have a trade secret that's enforceable. Because the biggest defense against trade secret misappropriation is that wasn't really a secret. All the sales guys knew it, and all the customers knew it. It was out there, everybody knew it, right? It wasn't a secret. Here's a guy sending some customer an email about this, right? It's not going to hold up as a trade secret. Right? So we've covered the first three. Now we're going to get to the fun part, patents. Patents are the coolest stuff, right? Patent attorney says, okay, let's see, can we get? There's lots of different types of patents. And these are the most common, the ones that I usually see in my practice. There are other types. There are plant patents on asexually reproduced plants, right? There are patents on semiconductor masks There's other types of patents than those that are here. And I have people who are experts on those different types, either Ramon or outside, that I can refer you to, because those are a very narrow specialty area, plants, for instance. These are the three types of patents that a startup is most likely to encounter. Right? There's the provisional patent application. There is a non-provisional patent application, and there's a design application and patent. The provisional application is not a patent, it is only an application, and it does not turn directly into a patent. The non-provisional, sometimes referred to as utility application, that's the application that turns into a utility patent, right? So what's the difference? A provisional is something that's a temporary placeholder. It's just a way of putting a stake in the ground, right? I've got this today, right? I file it with a patent patent office. It can be an informal document. It can be a white paper. It can be a deck. It can be 10 pages written by a patent attorney, plus your white paper, plus your deck, all stacked together and just put on the record, right? To establish what you had on that date. The provisional application only lasts 1 year. That's a hard deadline. 1 year from the day you file it, it will expire. It'll go away. The way you get a benefit from it is you file a non-provisional patent application of some type. And in that non-provisional, you say, this application claims priority of this 1 or 2 or 10 provisionals that we filed in the last year, okay? And that's called claiming benefit of a provisional. And that means for what was in the provisional, you get the filing dates of those 1 or more provisionals. Right? In a non-provisional application, I've seen over 200 provisionals, right? This is wacky, but usually in the first year, a startup might file 3 or 4 or 5 provisional applications because they're developing their product. And at the end of that time, they roll all those 5 up into one nice, well-prepared non-provisional patent application. The non-provisional patent application, a utility application, for instance, is the type of patent application that gets actually looked at by the patent office. It gets examined, and they decide, is this something that we can, is going to issue as a patent? And that process, we'll talk about it a little more in a bit, and that process can take several years, all right? There's other types of non-provisionals. There's something called a PCT application, which takes, which is related. It's basically an option to delay filing outside the United States. In a little bit, we'll talk about, we can talk about that. It gives you 18 more months or 19 more months, depending on the country or region, to decide if you want to file your application outside the US. So if you have something and you think that someday Samsung's going to be your acquirer, right? You've developed a technology that's right in their space, or Honda, or some Australian mining company, right? If you're in that space, you probably want to have a patent in South Korea or Australia or Japan or some other place, right? The PCT application is just an option that gives you you pay a bunch of money and you get an extra 18 months. The non-provisional application is the thing that gives you enforceable patent rights. You don't have enforceable rights until your patent issues. Okay? It lasts 20 years from the filing date of the non-provisional, usually. If for some reason the patent office takes a lot of extra time, you might get a little term extension on the end of that, a few months or a year, perhaps. And it costs much more money. This is a document that is not informal. It is written by a patent attorney who will probably charge you a significant amount for the drafting of this application. And then after you get the application on file, there's the patent prosecution office where the patent office goes back and forth and you end up having to pay even more. We'll talk about the budget in a little bit. Yes, I promise to do that. The last type of application that I see with early stage startups is a design application. And in principle, design applications are supposed to cover, quote unquote, the oriental design of something, right? Not the utility, but how it looks right? So examples of things you might get a design patent application on: a car hubcap, right? That looks really cool. A potentially a website layout, maybe. Um, One of my favorite design patents, the law firm I first worked for did this patents, was on the um, Polycom speakerphone. And I like this story because in the old days, I'd probably be sitting in a conference room with a potential client telling them the story with a Polycom phone in front of us, right? And it had a really cool triangular shape. It turns out that shape is really nice because it had microphones out on the edges and a big speaker in the middle, right? Which gave a nice, good sound. And that would be considered a utility aspect of Polycom's inventions, right? So that the big sound part would be covered in the technology behind the electronics would be covered by a non-provisional utility patent application. The design application was on the shape of the phone, right? And Polycom actually litigated this against competitors because it turns out that the alternative was either like a four-pointed star or something that looked like a flying saucer that was round and didn't look at all as elegant on the conference room table. So that turned out to be a really valuable patent. There's design patents that you might have read about where Samsung and Apple are battling each other over the features of a phone, right? Those are design patent applications. It's moderate costs, a few $1,000s, mostly in preparation of drawings. It only lasts for 14 years, but it can be valuable. And on occasion, I have had clients that do design work. The most recent I can think of was an insect trap, right, for managing insects in agriculture. That was a design application. All right. So let's go on a little further. The next big question I get from a lot of founders is, will I rule the world? They'll come down and say, well, we have a market everywhere. We want to file a patent application in at least 150 countries, right? And I think to myself, oh my gosh, this startup's doomed, right? They have no budget, no real idea for budget. Patents outside the US are expensive. Most countries, even while a patent application is pending, charge you an annual fee that can be from a few hundreds of dollars to a couple $1,000s. If you want a patent in China, you have to have, your patent attorney will help you engage with a Chinese law firm. If you want a patent in Europe, right, we use a European law firm. So there's a local counsel in whatever country, whether it's Canada, Australia, Japan, South Korea, Singapore, Israel, you will end up paying for more and more attorneys. So it can be quite expensive. In reality, I have some rules of thumb about where you might want to file, and this is on a very particular criteria. What do you expect your market to be in South Korea? How many units do you sell? In 5 years, what do you imagine? Is a South Korean company going to buy you? Are they one of your potential exits, right? If you think you're going to be bought by Samsung or LG, then by all means, let's get something filed in Korea. If you think that Toyota is going to buy you or Sony, then by all means, let's get some IP in Japan. Right? If you have a really big market in Europe, or if you are a mining company, you might be in parts of Asia or China or South Africa or Australia, who knows, right? So there's a market segment. There's a consideration of your potential exit. So this means I ask founders, like from day one, what is your plan for an exit? And having a plan greatly increases your chances of getting there, right? Companies without a plan tend to languish. The other thing that you might think about is where the competitors are, right? We have one big competitor and they are in Norway, okay? So you will get a patent in Europe that protects that place. So those are three of the criteria that you might consider getting patents at if you want to go outside the US. It is highly unusual to do more than a handful of countries, right? You can do Europe as a entity, as a single application. It's expensive, but it's all at once. The same with a whole bunch of Central African countries. There's some regional patents you can go for. But more than 3 or 4 is really unusual. The only companies that do 30 or 50 are pharmaceutical companies. Now, they will get patents in companies all over the world because their markets are so valuable in each one of those countries if they have a good drug. Okay, next question. Well, how are we doing on time? We're good. We're good. Okay. When do you start this? You start it right away. If you're a solo founder, that simplifies things a little bit. If you are a team, you have to think about IP from day one because there's some inventions, and in the US, the invention ownership starts in the inventors, right? So in your initial founding agreements, you have to figure out, are these inventions going to be assigned to the company? Are they going to be transferred to the company, right? What if we have a founder that leaves right away, right? After 3 months, they get another job and they decide to go somewhere else or do something different, or we have a founder divorce, right? And founder divorces are really not uncommon. They happen all the time, right? People realize that they're really not made to work together, and so you need to start thinking about the IP from day one because you have to figure out what's going to happen. So very often, I'm the first attorney that people come and talk to before they even talk to a corporate attorney, right? Because they want to get the IP nailed down. I see some questions coming up. Yes, I will go through the Q&A tab. I see the Q&A tab is open, and the webinar chat, I will start answering questions in about 30 minutes. So yeah, you want to get this done right away. IP attorneys tend to be pretty business savvy, working with hundreds of startups over the years. I am happy to review your deck. I'm happy to make introductions to investors that I think are in your space. All those things I can do for you. I don't charge for that type of stuff. That's part of the fun of working with startups is you get to be part of their ecosystem and you get the excitement of building something from scratch. So start thinking about IP right away. In most of the world, including the US, it's a first to file world. And I have had situations where my client and their competitor, we're talking 6 days, 7 days apart, right? Getting something on file quickly is the advantage of provisional applications. I have clients that say, we came up with a new idea this weekend. Here's a 5-page write-up of it. Please file it by Wednesday. Right? They want to get stuff filed quick as possible. And that provisional may not last. It may be something they decide not to do anything with, right? And it'll go away. But then later, if it turns out to be something important, boom, they got a filing date. So that's great. All right. I'm going to show now a slide that you won't see in a lot of people's presentations. I'm going to talk about budgeting, right? Because I think budgeting is really important for early stage startups, right? I always talk about budgets with my clients, so they know what to expect from me, right? There's got to be a limit over which they're not going to get a bill from me that's 5 times more than they expected and blown away. Budgets are important, especially for an early stage startup. You want to know exactly how much everything's going to cost, right? Especially if you're pre-funding, if it's coming out of your own pocket. So I'm going to give you a slide now, drum roll. This is just an illustrative example. Your experience will vary, okay? There's going to be something different, right? It's not going to be exactly like this. But this is a typical case. Where's my button? Oh, boom. Okay, what does it cost? This is in US dollars, by the way, not rupees, okay? or euros. So a provisional application you can do on your own if really necessary. There's a good book available on Amazon from Nolo Press called Patent Pending in 24 Hours. And that book is how to spend 24 hours of your time to get a provisional patent application on file, right? So the book's probably 30 or 40 bucks. I haven't looked late in years, but That's something you can start with. I have a program. I charge early stage startups flat 2,500 to get a provisional on file. And this means that I will interview them, dive down in their technology. I will write a set of claims. I will give an outline. I will throw it back at them and say, maybe I'll do some drawings and say, fill in this outline. Okay. It doesn't cost lots of money because the inventors, the founders are doing a good part of the work. Okay? And that's a flat fee, right? Including all the patent office expenses, about $2,500. And if I have a client who says, "Oh, we don't have $2,500," then my response is, "You need to have money, right? I know you're bootstrapping. Go back and work for 6 months and save up every dime you can. A startup needs to have some cash. You will want to do patent applications. You will want to do a really professional website or hire a marketing person for a little bit, or contractors, or do some corporate law work. There's a lot of corporate attorneys that will do your initial incorporation for a percentage of the company. Go figure out what that percentage is and what it's really costing you in equity. It's not worth it. Okay, you're usually much better off paying $3,000 or $4,000 to have the attorney do the work than you are giving away what becomes, $100,000 in equity, right? So a provisional application, it lasts 1 year from the filing date. Within that year, as I've said before, you have to file a non-provisional. Non-provisional is much more expensive. Typically, um, this could, I tell a startup, budget somewhere between $15,000 and $20,000 for the non-provisional, right? Because the patent attorney is going to spend tens of hours working on that. Right? It's going to be expensive. Sometimes there's a tight budget and we kind of scrape it by and produce a product that's not ideal, right? You get what you pay for in terms of attorney time. So, but in a first year, it's not unreasonable. I will tell a startup, for your IP budget, if this is a Silicon Valley type early stage startup, you want to be budgeting 35 to 50,000, depending on how aggressive you are in your first year after funding. Okay. Hopefully, the day you filed your provisional application, you went and started talking to investors, and within 6 to 8 months, you've raised money, and now you can afford the patent office, right? If you can't raise money in a year or so, then maybe start thinking about a different project, right? And forget what you've done, because you're only asking people for money, and you just put a year of your life into it, which is a lot more valuable. So you ought to have some money in the bank. Otherwise, investors will smell it. Like, we've really got to raise money this month because I need to pay rent, right? That doesn't go over well. That means the investor is going to take an extra 6 weeks putting around, and the terms are going to change. And all of a sudden, you're going to be, over a barrel and in real trouble because they're going to hold you up. Investors are going to use that against you. So have some money in the bank and don't be desperate to raise money. Okay. That's to get the number I have here, 18,000, is typical to get an application on file. Now, after it's on file, there is what's called office actions. Usually, 95% or whatever percent of the time, the patent office will reject the first round of an application, right? They will have some complaint about it, maybe some prior art that invalidates it, or some vagueness in the claims, or some other issue. And your patent attorney will then have to respond to that office action, and that response is going to cost a few $1,000s. And that average patent application that issues takes about 2 rounds back and forth. And that's just the average. Sometimes it's only 1, sometimes it's 5. Okay, I had something allowed yesterday that, had been 5 years, right, pending. And we had, I don't know how many rounds we have, but it had gone all the way to appeal. And right, we paid the appeal fees, which are expensive. And all of a sudden the examiner gives in and agrees with us because she knows we're going to win, right? So this amount between getting it on file and actually having an issued patent can vary a lot, tremendous amount. But 30,000 is kind of a reasonable bet. You're going to spend another 10 grand or so on prosecution, and then there's issue fees and other stuff like that. Right? Now on the slide, I have 2 lines. right? One is the first application, and the other is the family. So patent applications can be related to each other. You can file a patent application and then couple of years later file a daughter. And that daughter gets the original filing dates and priority from its parent. In the US, this is very, very useful. It's not always so available outside the US, but this can be very useful. That means you can say, oh, we didn't quite focus on the right parts of the invention in our initial application. Here's another set of claims focusing on this different aspect of the invention. It could be that your specification, your application has 5 different inventions in it, right? You packed everything you could in that first year, a lot of stuff. And now you go after one after a time under a managed budget. You go after one of those inventions at a time in separate daughter applications. Daughter applications are much less expensive because you've already written most of it. There are types of daughters called a continuation part where you add more material, right? And the new material gets the later filing date, not the original filing date, of course. But there are only a few, they can be a few pages more. So there's not a lot of writing. And I have gone back in my clients and looked at the cost of daughter applications compared to the originals. Hold on. And I see the cost might drop, get something on file, $9,000 to $11,000 a piece, right? And that depends a lot on how, the filing fees and the, how much new material we've added, right? So after 5 years, your early stage startup might have a portfolio that started with a handful of provisionals, became one non-provisional application, or you're in a PCT application, and over the years has now developed into a whole family of whole patent portfolio. Right? That's the ideal situation. That's a cost-effective way of going about it. All right. Let's see. Anything else I want to cover? Yes, cost. And your costs will depend very much on what you're doing, how unique it is. If it's business software, it's much harder than if it's a insect trap. It has some unique chemicals in it, right? It depends on the uniqueness, the type of technology. Business method patents are possible, but harder to get. Nice, clean mechanical devices are easy. I'm looking around my desk right now for things. I was going to hold up something. I think here. All right. I had a light bulb a while ago. I wonder where it went. I have boxes of LEDs all around my desk here because I've been working on LED stuff. All right, let's go move on. Let's see. Mistakes. Things. I have a whole seminar on this. You can look for it online or look for Idea to IPO to post the next time I give it, maybe sometime later this year. You can find it on YouTube. These are 5 mistakes that early startups often make. And I'm going to go through this relatively quickly right now, highlight a couple of them. But again, I have a whole presentation on this one subject because I see it so much. The first 2 mistakes, ownership. That's not a typo. It's ownership and ownership. Those are the top 2 mistakes. W, 2 for nothing, right? Waiting too long, okay, focusing on IP. And then not having a good strategy, and finally not understanding the patent. Right? So let me kind of go through those one at a time right now. Ownership, all right? The first type of ownership is making sure you own your IP, okay? Ownership in the US, by default, falls with the inventors, right? Not the company. Even if you're the founder, or you have a co-founder, or your CTO invents something, when at the time of invention, and probably at the time the application is filed, the inventor owns the technology. You want to make sure that there is a clause in the employment agreement or in the contractor's agreement, whatever it is, that says that the person you're hiring has a duty to assign their invention to the company, right? That's really important. So here's where IP intersects employment law. And somebody asked me earlier whether it's different in different states. Yes. California's rules are a lot different than Florida's, right? Florida is more corporate. friendly. California is more employee friendly, right? On what they would be assumed to be owned by the company. Right? There is an assignment process. Okay, you should have language in the hiring documents, whether it's a contract, even if it's a salesperson. You should have some IP language in there saying that this person, anything they do with your regard to your company is assigned to your company. It could be a web designer, right, who works for a web design company. There should be a clause in there that the website they design, the IP in that website, the copyright is owned by your company and they agree to assign it. Okay. So you need to have all that kind of language in there. One of my favorite stories is Adobe Forms. Adobe, right? We use Adobe Reader and Acrobat. The Forms technology, which is cool and very, very useful, that was invented by a sales guy, right? At Adobe, right? So hopefully Adobe had in his sales contract had something that said, yeah, even though you're a sales guy, you might come up with a cool idea that is important to us, and we want ownership of that idea. So make sure there's IP clauses in everybody's contract, right? If it's a house, a web design company, they're going to want a much more shallow IP clause, like only your website, not everything they do belongs to you, right? If it's a key employee in engineering, then you want a much more aggressive IP clause, right? And how aggressive that can be depends on the state that the employee is located, right? So in California, it wouldn't be okay to say, we're a software company making self-driving cars. And by the way, if you invent a new lawnmower blade, we own that too, right? That would be an overreach, which could kill the whole clause, right? You don't want to do that. You might get away with that in a different state. So again, this is issue. The second way ownership can mess you up is other people's IP, right? You want to make sure that an employee doesn't accidentally bring a bunch of source code from his last job and put it in your product, okay? You want to make it very clear that, part of the employment agreement is a statement saying, I will not bring IP owned by others into your products, right? I will not make that mistake. One of the ways this can happen is open source software, right? It's okay to use open source software, but you have to actually read the license. There was a couple of years ago, there was a famous case. A certain politician put out his own version of Twitter, right? And they based their whole system primarily on open source software. And after their release, I'm not going to say who it is, after their release, that open source consortium came to them and said, our license says that if you use our open source software, you have to make your own product all open source. Please give us a copy of all your code so that we can publish it, right? And so very embarrassing. They had to pull the product off the market, right? And then 6 to 8 months later, after they rewrote everything, they released again, okay? That's called, not paying attention to the law. Pattern repeats itself, apparently, okay? There is an assignment process. Just like when you buy and sell real estate, there's a recording system. So there's a public record of who owns what applications or who owns what patents. Okay? And there's a recording system where your patent attorney will take an assignment document from your employee and record that with the US Patent Office, showing that the ownership of an application or patent has been transferred from the inventor to the company. When your company is bought, again, all the IP is transferred to the buyer, right? And that all goes through an assignment process. So be aware of that. It's not just like, yeah, Joe said we could have all his inventions. I have a note from him here, right? In the meantime, Joe's off and selling it to somebody else, and you're not paying attention, you're out, right? The new owner owns it, okay? So you have to pay attention to the assignment process and be aware of it. Okay, another mistake. Let's see, what was number 3 mistake? Yes, strategy. Okay, how much time do I got? All right, 13 more minutes. strategy is important. Patents are to increase your valuation, right? Remember, that's the first thing we learned. Patents are for the marketing and sales guys, not the engineer, okay? You want to make patents more than just a checkbox in what you're doing. You want them actually to be on stuff that makes a difference to your customers, right? If the customer doesn't care about some little electronic circuit inside your VR headset, and that circuit doesn't enable a feature that matters to your customer, I don't care about patenting it. When you're pitching your company to early investors, you're probably saying things like, we are going to be the winner because A, B, and C. We are the only people in the world who's got A, B, and C, right? These three features will make us fantastic. We're going to conquer the world. We're going to be $1 billion company, and that's why you should put money into us, right? Well, A, B, C are the features that make you really valuable, okay? Those are the things you want IP coverage on. So your patent attorney should be asking you questions about not just the technology, but the business plan. What do you expect your exit to be? If you expect to be bought by a mining company in Australia, okay, we got to write patents that are valuable to a mining company in Australia. Okay, what are the things that are going to drive your customers? When you have a product on the market, you've got sales guys out there and marketing people that say, we're the best because, and there's A, B, C, maybe D's now popped up, okay? Right? We're the best at, so we've got A, B, C, and D, and you can't go anywhere else. You got to buy our product, right? Those are the things that we want to cover patents on. Now, it might be that the feature that's really good is we can build our software lets us build websites in 3 hours where it took 3 months, right? We're really efficient on that. Or we can do market testing on your website automatically without anybody having to code anything, right? That's the feature, right, that sells the product. Now, there often is a technology behind that feature, okay? So if you tell me, oh, we do automatic A/B testing of websites, right? And the web people don't have to recode everything, and the marketing people can just do it, right? Then I say, okay, what's the technology that enables that, right? And that's the technology we write patents on. When my clients get to like a B round or A round, B round, when they're raising big money, tens of millions, I will give them a slide for their slide deck that shows those magical features and all the patents and patent applications that relate to those, and a bunch of lines crossing, make a big spider web. I call it a cluster map. And the first patent attorney I ever worked for taught me this. It's a document that shows the relationship between your IP portfolio and those magic features, right? And those magic features is why your customers buy your products and why your investors are going to invest in you. Those are the things. So you want to connect those. And if you show a slide in your deck, here's our 15 patents and patent applications, and here's how they all relate, and they completely cover from all these different ways our 4 magic features. That's going to make the investor think more, right? Like, oh, there's an IP portfolio. It's not just a checkbox, right? Here's an IP portfolio that really makes a difference. Okay. Right. So your strategy is for the marketing people. It's product driven, right? You're remembering that the reason for IP is to increase the valuation. So you want it to be related to the things that make your company valuable. And you want to convey to investors that IP is more than just a checkbox. You have actually worked at it and developed an IP portfolio that it makes your company more valuable and your take home when you exit more valuable, right? That's the goal. Okay. Oh, yes. Other people's IP. Kind of out of order, but big companies, your Intels and your Googles maybe, and so on, they don't encourage their employees to go out and read patent literature. And the reason behind that is if the company becomes aware, or the employee becomes aware of something that the company is infringing, the damages for patent infringement may go up. So big companies, if you work for a big company, they don't want you reading patents, usually. A startup is a little bit different, right? So I come from a science background where we were encouraged to go out and read the literature. We spend Friday afternoon in the library seeing what everybody else is doing. because it's going to give you ideas, and you don't want to reproduce, others' inventions and or discoveries, right? And keep good records of what you do, like a lab notebook. I used to have stacks of lab notebooks, right? I developed over the years. So for startups, I encourage companies to go and look what's out there, what people have already patented. Go to patents.google.com, go in your space, go look at your potential competitors, find out who the big inventors are there, see what they've done over their careers, get an idea of what other companies. It could be that you find something that is dead on and kills your idea. All right, disappointing, but it's better to find that out now than in 2 years, okay, or 3 years, right? When people have put hundreds of millions of dollars into the company, and um, uh, you find out somebody comes knocking on your door and says, "I have a patent," blah blah blah. If you're a startup, you can engineer around. You can say, okay, well, let's make the product a little bit different. We still have a core idea that's good, but let's go in this direction and avoid this person's IP, right? And maybe in a few years, when we're doing really well, we'll buy them. I've seen that. Okay. So I encourage to read about your competitors. I encourage founders to read about your competitors. Go look in the patent office in Google Patents and read other people's inventions. Very often you'll read something and go, ah, that's a really cool idea, but they're doing it a little bit wrong. If they knew about our technology, they'd do this. Okay, boom. You just had another idea. We're going to cover it with a patent application, and that way you've put a block in front of your competitor and moving in your direction, right? When they see what you're doing, they'll go, oh, these people have already patented the improvement on their technology that includes your ideas and technology, right? You've got a patent on that. Very valuable, very useful. It encourages people to buy you. That's what you want. Okay. Keep records. Keep a notebook. I prefer a hardbound notebook. Nowadays, I often keep records on a computer, right? If I'm in a Zoom meeting, I'm taking notes. I save those. I have a way of saving things because I work for a law firm. We can archive files and prove that when they were written. Personally, I have an email account where I throw things like leases and contracts, and I've been using it for almost 20 years. It's got all these financial records. Don't tell anybody, but yeah, it's a way I keep a depository, e-depository, and I have used emails to show inventorship and show I got things first. Now, while we're still in a first to file world, this still matters. If you're the really good founders that I know, they often sit down with you and they open a notebook, right? And when they're taking notes during what you're telling them, right? This can come useful all kinds of ways, right? There was a a meeting we had with 7 people in it, and this idea came out of it. Whose idea was it? This reflects on inventorship. Who's going to be on the patent? Well, somebody had good notes of that meeting, and it was these 3 people that together got this, right? Saves a lot of time. Let me give you one more example. I'm going to wrap up the lecture part of this in just a minute. Let me give one more example. Let's say you have a great meeting and you come up with this brilliant idea. It's actually groupthink. 4 of you came up with it together. You wrote it down in your notebook, right? Maybe you scan your notebook every week and upload it to a file depository somewhere. So you've got got a physical copy, a dated notebook, and you've got electronic copies. You're in good shape. And then 6 months later, you're doing great. You hire somebody, right? And a year after that, that person's helped build the product, and his former employer comes along and sues you for trade secret misappropriation. Saying you hired an employee, and look, 6 months later, you've come up with a product that has this great feature in it that he got from us. And you go, no, wait a second. He's not even on the patent. I have this notebook from a meeting 6 months before he even joined us, and who is on our patents, right? So we have a patent application we filed before he joined, and I have a notebook that shows all this stuff. And you've just turned, I mean, it's still going to cost you, but you've just turned a $500,000 litigation or $1 million litigation into a $20,000 legal cost, right? You're going to put these people away. Okay. So keeping records for so many reasons is a good idea, right? All right. That is it. Okay, this is out of date. So this slide's a little out of date. We're more like a dozen countries right now. I know our Moscow office closed 5 years ago, or 3 years ago. Ramon is about 250 attorneys. We are in lots of countries. We have offices throughout the United States and Europe and Asia and Middle East. So pretty broad. We do all kinds of work. There's about 20 patent attorneys in the firm. We do everything else, corporate formations, aircraft leading. We have a big entertainment group. We can do wills and trusts and states. So when you make it big, we can meet up, introduce you to people who will help you manage your tens of millions or hundreds of millions of dollars. Let's see. There's a lot of bands. I'm not going to name any names, but we represent heavily in the music industry, aircraft leasing, gas and oil, mergers and acquisitions. We do IPOs. We're a full service law firm, white collar crime. In my career, as in the 25 years I worked for a law firm, there's only been a couple of times where my clients have needed a criminal representation, and I have people I can recruit. But hopefully only a couple of them. CTOs, sometimes they're a little, anyway, I'm joking, of course, right? But we can do everything. Real estate, leases, all that kind of stuff. So that's it. Now, there's my email. I will try to answer your email if you send it to me. Welcome to connect with me on LinkedIn. That is my work phone number. I am in the Pacific time zone in Nevada or California. And if you send me an email or ask on LinkedIn, I will send you a copy of a link to my lecture on understanding a patent. Oh, I didn't cover that. That's the last of the mistakes, not understanding a patent. What does it really mean? What's the difference between the claims and the body, right? What's the difference between an application and a issued patent? Right? I have a seminar that's on YouTube. You can probably search it. It's called Anatomy of Patent. But if you write to me, I will send you a link to that. And I'm also happy to talk with you for a few minutes about your individual situation and make recommendations, stuff like that. I am now going to plow ahead. Look, I'm on time. Okay, I'm going to go look at the Q&A tab first. That seems to have a couple things in it. And I'm going to drag it over to the middle of my screen here. And I'm going to go through and answer the questions. Okay. This is from Don. Thank you, Don. I am working on my provisional patent application. Not a patent. It's not a patent yet. Wrote you to schedule an intro and discussion. Good. I'm happy to meet you. My previous firms, I won't mention their name, but it's there in writing, filed my first patent years ago, which expires in 3 years. Okay. The new provisional is different than the original. That's good. 17 years ago, yeah. My provisional is a workflow-related patent for ultrasound scanners. Did you not respond because there was a conflict or not an interest? Which is fine, as I have other IP attorneys. Okay, I should respond. I promise I will respond. Hold on. Wait. Don. I'm sorry. Maybe my admin thought it was something else. Okay, I will respond. And I do have experience in ultrasound. So this is a good question. Conflicts, all right? So if there's in other areas of law, like real estate, right, and you're doing real estate contracts, it's impossible for a law firm to represent both sides of the law firm, right? It's a conflict of interest, both sides of the deal. In patents, we have a different kind of conflict called subject matter conflicts. And that means that if I have an ultrasound client, I have ultrasound clients. If somebody comes in with an ultrasound invention, I will hand it off to another patent attorney at the firm right? And we're using electronic file management stuff. We create a wall between those two, and both clients have to agree to this. Right? But we run a conflicts check, and if it's ultrasound and ultrasound, it really depends. So I was doing, 20 years ago, I was doing broadband reading heads for ultrasound, and now I'm doing ultrasound for premature birth. Okay, so those are different areas. If you are doing ultrasound in an area that's not babies, right, and birth estimation, then I'm likely to be saying, okay, I can take it. If your ultrasound that's in for babies, I'm going to hand it to another client. If it's ultrasound for the same purpose as my client, then I'm going to send you to another law firm. Okay. But those are how we handle the conflicts. And yes, I will look at it. Sorry. Can you eliminate, next from Steve, can you eliminate the process on which what happens when a non-provisional is filed? Typically what happens with the PTO. Okay, so right now, the PTO has not been touched by Dodge. I mean, they've been threatened, but so it takes, depending on the technology area, a year or two for them to get to your application, right? You can pay extra money and get it done much quicker, get things accelerated. But if there are cuts in the patent office, and specifically most of the patent office, 99% of the examiners work remotely. There's not even a building right now for them to go back to, right? It got leased out. I can't tell you what the patent office timeline is going to be. Right now, it's pretty good. 20 years ago, it wasn't unusual. It could take 6 or 7 years to get a patent, right? And you'd get term extension on that. It was which is now nice. But it was long and slow. We could be going back to that, but typically I expect if you're a software company, let's say a dating app, I expect the patent office to get to you in 8 to 14 months. And you'll get a first office action, which is 95% of the time rejection. And you can either argue about why it shouldn't have been rejected, or you can narrow your claims in order to get around the objection, right? And you might go back and forth several times with the examiner. You might disagree with the examiner and come to disagreement, and then you go into an appeal process, right? You can even, in theory, go to court, fight the patent office on something. But hopefully in 3 to 4 years, you will have a patent. By then, you will have filed a bunch of daughter applications off your original patent, and you will be growing a portfolio that makes your company more valuable. So it takes a while. It can be accelerated. If you pay a couple $1,000, you can try to get it, in theory, all done within 12 months, right? But most startups don't do that. Some do. I have a client right now that's saying, okay, we want to file 5 things this year. We're going to pay 10 grand on getting them accelerated, because it's a hot space. So that's the story. That's what happens. There's more costs, and it varies widely. If your patent is allowed right away, your claims are probably much too narrow. Go listen to my talk on anatomy of the patent if you really want to understand the claims. And so what I often see is somebody will come to me with a patent saying, "Oh, I got this patent. This guy in upstate Minnesota got it for me. It only cost 5 grand." And I look at it and I go, and it was allowed on the first try. It has one claim that's a whole page long, and I'm like, "Oh my God, this is worthless." Right? Go see my seminar to understand why. But if you get something allowed right away, typically you'll take it and then you'll file a daughter application with broader claims, right, to get more, right? But we'll see. But that's what happens. Okay, Anonymous. Welcome, Anonymous. Come to all my things. Okay, I'm an inventor who secured a design patent in 2022. It took 2 years with help of a law firm. Good. I own the patent, not my company. I wanted to design and manufacture a doll in China, and then tariffs that showed, but thinking, I received an offer to buy my patent from a Florida-based licensing company. How do I determine the value to earn a good profit from the opportunity? Okay, so that's nice. You are lucky to get that. The secondary market for patents It's like getting married. It's the eyes of the beholder, right? A patent that's totally worthless to one person might be worth a lot to somebody else. Um, I have litigated patents that were somebody tried to auction and it didn't sell at the auction, and then the litigation later is tens of millions. Okay, so it really depends on your ability. I do work, and I've worked with some organizations that help individual inventors sell products, not sell the IP, but sell the products. And they, if somebody wants to write to me, I'd be happy to give contact information. They're legitimate inventor-run organizations that help each other, right? They're not for-profit things that rip you off and say, "Oh, we're going to get a patent for you." So the depends on what the market will bear. How much you're going to get. I remember having one of my own patents issue and getting a call from Intellectual Ventures like the day after it issued, and they're like, "Oh, we'll give you 125,000 for that patent." I'm like, "Oh, well, there's some daughters filed. I bet it's going to be worth even more in a few years." I haven't gotten anything out of them to this day, right? I should have taken the 125. So we'll see. Yeah, I can give you advice, no charge on, this is business advice, not legal advice, right? On what you might get for it. It really depends. It's nice to get a little money up front. It's also nice to have a tail, meaning a small percentage of the uh, of sales, right? So if the doll is a huge success, you get the best. And the person that I um, who founded the organization, inventor organization I just mentioned, he actually came from Worlds of Wonder, the toy industry. So anonymous, send me an email, and I will give you his contact, his LinkedIn information, and he probably would have a better idea on the actual market value of a license than I would. Okay, next one, Kartik. What happens when you want to patent your product slash business model? In your case, we are ready to go to market, GTM, and you end up discovering that there are other companies working a similar proposition, but the idea hasn't been patented. Yeah. So if there's existing stuff out there that reads on your invention, your claimed invention, and the patent, then your patent shouldn't issue because there's what's called prior art. Okay. If there's something unique, and it could be something small, there's something unique about what you're doing, and you put that into a patent application and get patents on it, then you might have a big advantage over the rest of the market. So this is where you want to have a patent attorney who's bugs you about the business side of your industry. What is it that makes you different? Let's focus on what are the competitors doing? This is the type of thing a patent attorney should be asking you, because the claims they write in the patent application are really going to depend a lot on what the parts that distinguish you. And hopefully you get a part that distinguishes you that's also, a wonder feature, right? That makes it that your product will sell. And that's what you're going to pitch to your investors and your customers, right? We have this feature, right? So, and remember, there's a lot of businesses out there that are really successful without patents. Patent attorneys are not by any means a requirement. Okay, you can have a great successful business if you're a better business strategist without, there are a lot of ideas out there, right? And there's plenty of things that are patented that never turn into products. There are plenty of great ideas that never turn into products because the idea is a few percent. All the work in making it a product, right? That's 97%. All right, the sweat in building customer bases and sales and engineering and all that other stuff. The ideas are a dime a dozen. You can go to the NASA Tech Briefs, and NASA has a whole magazine on technology that's available for license. You can go to universities, the tech transfer offices, and find really cool stuff that you could license and build a business on. The value is in building the business, not necessarily the patent, right? In this case, you have other companies that are doing stuff, really find out as much as you can about what they're doing and how you're different, right? And talk to your patent attorney about those differences. And if there are differences that aren't going to make a difference to the customer, come up with more ideas or change your focus, right? All right, Do I do immigration law? Not personally, but I do. Ramon does. Ramon has several immigration attorneys, and we can do business-related immigration. Fine. I have two friends who are not partners at Ramon who do immigration law for people like refugees and will help fight deportations. I am perfectly happy to give references or referrals to people who do immigration law that are not business related, right? So again, Ramon's immigration attorneys are primarily focused on business, and but I have at least a half a dozen, or maybe a dozen other attorneys that are in the space. I have personal stuff. I have two Ukrainian children, right, that I adopted from Ukraine many years ago. And so I have a lot of connections. I've sponsored Ukrainian families. So I am right now pretty into the immigration law stuff, but and I would be happy to refer you to an immigration attorney of the specific type that you need. Great. All right, anonymous, sorry. What happens when an IP that just has a little portion pertinent for me expired? Can I use part of it? Okay, so if something's expired, then meaning a patent is expired, then good, it's in the public domain, you can use it, okay? Yeah, so once a patent expires, that's the deal, right? You put something, you invent something, you get a few years of exclusivity, and then it belongs to the world, okay? Will Dodge affect patent officers and policy? I don't know. I have a good friend, one of the attorneys that I worked for when I first started, who helped train me, is now I'm not gonna say which region, but she's a deputy director at the USPTO. And I asked her this question, and she said um, she hedged. So the patent office makes money. It doesn't cost the government anything. They actually send money from the patent office into the general fund. If they really wanted to enforce return to work, it would be a disaster. But who knows? I haven't heard anything about the impact on the patent office because they haven't. I mean, taxpayers don't pay for it. Inventors do, right? And companies that invent things do. So my hope is, examiners really love being able to work from wherever, right? And they're all over the country. And I talked to an examiner and I said, "Yeah, I'm in Duluth, or I'm in New Orleans, or anywhere, right?" It's a great job in terms of being able to work for the government and working. If you know somebody who's with a science, tech, engineering background and they're looking for a job right now, oh, patent office. Patent office will help you through law school, or at least they used to, right? And then you become an attorney and you spend 5 or 10 years at the patent office, get a little bit of government benefits, and you go into law, right? You become a patent attorney. So a bunch of my colleagues are former patent examiners. So I don't know if Dodge is going to impact them or not. I'm more concerned about the immigration side effects and really useful inventors or people in universities, the science in universities getting messed up. I think that's going to be a bigger. Can I help with incorporation? Yes. I have lots of corporate attorneys who focus on early stage startups, including things like founders agreements, and very cost effective. One of the advantages of Ramon, we are kind of an upside. Okay, I have time. Good. We're kind of an upside down law firm, meaning most law firms are a pyramid game, right? There's a few people at the top, and then there's like first, second year associates on the bottom that are the grunt workers. We are not like that. We have 5 times as many partners as we do associates, and we don't grow by hiring associates. We grow by taking senior partners at other big law firms. I didn't come from a big law firm, but people who have a big book of business and moving them to Ramon. So at Ramon, you can go to our website if you're an attorney, and we get 70% of our billings, which is a lot more than somebody at a typical big law firm. And the reason we can do that is that we don't have the real estate cost, right? We aren't in a beautiful conference room with wood paneling on the 23rd floor, right, overlooking the city. And our commutes are less. The bedroom to the desk place is much shorter. So we're much less, we're, 30% less expensive than, but we also at the same time have attorneys that have on average 20 plus years experience, right? And they can charge less than they did at the big law firm because uh, they don't need to cover it. The law firm's not taking a big chunk of it. So people who do very well at big law very often come to Ramon, right? After their first 20 years in practice and they've got good business, they come here and it's a much better situation, much less pressure, happier attorney. It's a great place to work. There are, we're probably the first. We're about 15 years old with the semi-virtual law firms. There's a couple of others out there that I have friends who work at, and it's fine. It's great. I still have a conference room if I really want to meet with a client. I have a conference room in Truckee, right? And that's near Lake Tahoe. And office there, I have conference rooms in San Francisco and Menlo Park, so that I can meet clients. But that only happens a few times a year, actually. Most of the time it's soon. Can we DIY our own plans? You can, on a budget, yeah. Can we DIY our own patents? Certainly provisionals, right? Go get the book, Patent Pending in 24 Hours, buy it on Amazon. If you have an attorney work with you, you have a much better product. Okay. So what you might end up doing is doing something on your own, and in 3 months, when you get a little bit of money, $2,500, right? I price that, I don't really get it's low, right? Um, because you better have that much money to spend on your company, otherwise you're going to be in trouble. Having an attorney work with you will help focus the patent on the important things and help the attorney can write the claims. Okay. But a provisional application can be a white paper. It can be a master's thesis. Put a cover sheet on it and file it, right? Before it gets published, right? Be a PhD thesis even, right? That'd be a little bit big, but you can do that and you'll get a filing date for what's in that document. Now, your patent attorney will say, okay, but you've missed some key things, or we definitely want to use different words, right? Something fatal is somebody writes in the provisional, you have to do it this way. There's no other way. It must have this feature B. Okay. And 4 years later, or not 4 years, 5 months later, they pulled feature B out. And that statement in their patent application is not true anymore. But believe me, when things are litigated, the other side's going to point to that. No, they said you have to have it. We don't have it, so we don't infringe their patent, right? So you can say things wrong. You can say too much. Don't include a background. I don't want to see a background section at all. It's just gonna hurt you. Um, yeah, and focusing on the tech, especially if it's something like software or business, you really got to focus properly on the technical side of stuff. You can't. Don't talk about advantages. We are better because of this and better because of that. And better, And a couple of years later, the examiner is coming back. Well, it would be obvious to combine these other references to produce what you have because, and then they take the words right out of your application, right? And that's used against you. So a good patent attorney will avoid a lot of stuff and make your patent application better. But if only it's only you by the book, at least read the book. Again, Patent Pending in 24 Hours by Nolo Press. Nolo makes lots of good self-help legal books. That's better than finding a patent attorney who says they're going to do it for a few $1,000s, right? That's not, I mean, like a full provisional, non-provisional. No, okay. Because hiring a patent attorney is like buying a car, right? You can buy a Yugo that doesn't really go anywhere for, well, you used to be able to for under 10 grand. You can buy a Jaguar. Now, Jaguar is different than it was. When I started giving this example, it was 20 years ago. Okay. You could buy a Jaguar and it'd be in the shop all the time. And you could spend 60 grand on a Jaguar, or you could buy a Camry that's going to go 500,000 miles, right? So the Camry was the right choice back then. So the price and the quality are not necessarily tied, but they should be. Anyway, find somebody who's familiar with your technology. So if I have somebody who's coming to me and it's a mRNA virus, right? I have a client in that space, but I don't do the work. I have a guy who focuses on biotech patents who does that. If you're going to be doing AI have an AI, somebody who's done AI patents. If you're doing AR, VR, I do lots of AR, VR, find somebody who's got experience in that. That will make a difference, right? You don't want to hire a semiconductor to do um, your agricultural robot. Yeah. Okay. Okay. What if I decide to patent after 1 year my startup? I understand it is important to raise the value of the company, but could a strategy be to raise funds and use part of the funds to pay for the patents? Yes. So the strategy should be file provisionals, on a budget of a few thousands. Okay. Raise the money and then file the non-provisions. Okay? It gives you a year to raise the money. And sometimes companies don't make it, right? And then if you make something public, right, and that includes showing your app at a trade show, okay, where the person at the show can't see and I got 6 minutes left, so I'm going to finish. The person at the trade show can't see what's happening on the server, it still counts as public. Okay, I'm going to give a story here. I'm just in my last few minutes. This rule came from the 1800s. There's a guy who invented a new woman's corset. This is a corset she wore to change the shape of her body, right? And this person used whale bone and put the bones in a certain way in the corset. And this woman put all her petticoat and the dress and all that stuff on and walked around in public with this corset underneath. Nobody could see the corset, right? Nobody knew where the whale bones were replaced, but the effect, like her shape, was publicly displayed. That counts as public use. All right. If it's an app and you're just showing the app running on your phone, that counts as public use of the whole backend. Right. In the US, you have 1 year to file after that public use or offer for sale. There's other barring events, offering for sale or public use, right? In the rest of the world, you don't have that 1 year. Right? Pretty much everywhere else. You don't have that extra year. So the minute you give a seminar on your product and you display your product on the screen, you say, this is the cool stuff we do, that's public use of everything you've shown in the seminar or the presentation, plus all the back end that supported it. Okay. So you don't want to do that because you will kill the possibility of getting patents outside the US. And lo and behold, it turns out that Toyota is going to be your acquirer, okay, or Volvo or whatever. And owning a patent in Europe or in Japan would have been really nice, okay, when you're not going to do it. So and if you're going to do a presentation, so I'll work with a startup, I'll say, give me 5, 10 pages on the core technology and give me your slide deck. I understand that tomorrow you're going to go out and pitch investors. Let's put a cover sheet on that and file it as a provisional. So whatever's in your presentation is at least we have a filing date before the day of your presentation. And it works with white papers, right? Pitch decks. Often I'll write up a bunch of stuff and I'll take the pitch deck and make an appendix to the application as a provisional. That's fine. It means that that deck was filed before it was public, right? And an investor pitch is usually public, unless it's really restrictive on who can attend. And there's lots of bells and whistles. You don't want to be in that position. So there's exceptions. There's testing, right? If you're a company doing road surfaces, you might have to test for 5 years. But then there's all kinds of rules about that. So in general, try to file first. The cost of a provisional cover sheet, the fee is like $130 for a small entity, less for a micro entity, right? So file first, something. It shouldn't be that, it should be cost effective. I have a client right now that's filing something probably every other month, and they're just saying, here's the list of inventors, file it. And I'm not even reading through it. It just takes me half an hour, right? But it's cheap for them. My cost is really inexpensive. What do I think about patent agents? Are they cheaper than lawyers? Yes, generally. Can they get the job done? Sometimes, yes. A patent agent is somebody who's licensed by the patent office rather than somebody who has a law degree. So a patent agent can't help you with an assignment, can't help you with a lease, can't help you with your child getting arrested, all the other things patent attorneys have to deal with sometimes. Um, so they can find one in your area. Very often you'll find one that was an examiner. So I have a guy that I work with sometimes who's a specialist in optics, right? And he's really good at optics. And he was spent 10 years as an examiner doing optics. Okay. And if I have a company that's doing the really cool technology used in AR, VR headsets, for instance, then I might bring him in. And he's definitely billing less than I at a lower rate, but he takes longer. So depends. Certainly he's not going to give business strategy on stuff, right? So I have alternatives. If somebody were to come to me and say, this is my budget, my investor says I can only spend 8,000, I'll send them to this guy, right? And I might even spend an hour or two reviewing it if somebody wanted it. But we are more expensive. And Silicon Valley type attorneys are more expensive than somebody in Chicago or New Orleans. But the quality, but for a startup, you kind of want to have the Silicon Valley edge because we understand what you're going to be raising money and stuff like that. A patent agent isn't going to have that. But I don't, patent agents can be good, right? Especially get one that's had plenty of practice. And if they say they're going to do it for $2,000, no, run. Okay. Um, our big law firms are law trims a rip off. Yeah, they trim it off. No. I wouldn't say that. I've never worked for a big law firm. I started working I was a CTO for most of the 90s of a chemical instrument company, doing patents as an inventor and designing products for companies like PerkinElmer and what's now Agilent. So I used to do a lot of trade shows. I used to sell and make products in engineering, right? Um, I'm a product guy at heart. So and I never did the big law stuff. So I've never worked for any of your giant law firms. I was fortunate. um, in the firms I've been at, it's only a couple others since, and they were all small. Ramon, other than the university, is the biggest entity I've ever worked for. So other law firms have always been under 40, yeah, 10, under 10 in some cases, right? Um, so are they a ripoff? Well, it depends on what you're trying to do. They're good people. I mean, it really depends on the specific attorneys you're working with. So there are costs that they bear that we don't, right? So it's hard. Have less flexibility in pricing. So that expensive boardroom and that giant skyscraper does the real estate from a business point of view is something that makes or breaks law firms. If you're dealing with, um, if you're Boeing and you want a law firm to represent you uh, against United Airlines, you will probably end up, it's a bad example, so we could do that. If there's politics involved, right, a big law firm is going to have a lobbyist, right? My dad was a lawyer who worked for a big law firm and represented and knew lots of politicians, right? So they can have connections there. If you, I mean, I have a great circle of investors, right? I do work with venture capital firms all the time. If you looked at my LinkedIn, you'll see. Um, so I have a pretty good focus. A big law firm might have more, but then you're going to be their little client, right? You're going to be the little tiny startup client, and their other clients, Procter and Gamble or Yahoo or a big competitor in your space. They're going to pay more attention to their big clients than the small clients. But I wouldn't blanketly say big law firms are. It really depends on the person and your use, right? Okay, moving down. James, does it make sense to patent an idea before having a functional prototype? Yes, you do not need to make a prototype. Absolutely. Block diagram, especially software. I mean, software patents are mainly block diagrams and some illustrative embodiments. I don't know if you can see my friend over here. Is he showing up? Up there's ears. This is a cat. That means pumpkin. Okay. Yes, file first. And this is advantage of a provisional. Okay, I'm going to finish up really quick. Advantage of a provisional application is that if you file something and you've only spent a couple $1,000s on it, and then you start implementing and realize it doesn't work, or you really need something totally different, or the idea evolves, then you've only sunk a couple $1,000s into provisional, and you can go and do another one. If you spent 18 grand on a non-provisional, it's much harder to say, forget it. Right. So file early. Hold on. Okay. What are the, oh, my screen just went blank for some reason. Okay. I'm going to finish up here really quick. What are the 3 or 4 questions you will ask and we should be ready to answer when contact? What's your exit plan? What are the features of your technology that people are going to buy? Do you have a founder's agreement? What's your relationship with each other? Are you married? Are you, have you worked together for years? And then I'll ask you about what other, you have agreements in place, your corporate status, your sources of money, things like that. I don't think the tariffs, I think the tariffs will, next question is about tariffs. I think they will have an effect on the economy. Being a patent attorney, we're somewhat okay with patent issues, somewhat protected from the ups. It's not like being an M&A attorney where if an M&A stops, everything goes crashing down for a long time. My clients tend to continue to file applications through economic swings as long as the clients are still alive. Can I help with patents on exchange for equity? Yes, I can, but it's rare, like once a year. Okay, so it depends on your company. But there are companies, and it's the way I do it is I will agree to invest so much in your company, and I will pay like 25,000 of your bill. Right? I won't put money into it. It'll be safe, just like all the rest of your investors, but my 25 gets spent on my legal fees. Okay. Will venture capitalists fund a startup that does not have a patent? Yeah. Usually it helps to have at least applications. It shows you've got your act together, you've thought about it. You probably won't have a patent when you first get funding. And it takes a few years to get a patent. They'll look at it, at least they'll ask you about it. But again, they will. I will. All right. What if someone uses our brand name without our permission? It's expensive to go after them. Yeah. What if they're in another company? Yeah, it can be quite expensive. We're not going to talk about litigation here. A patent litigation budget's low end $1 million, high end 10, right? 2.5, 3 million bucks. So a patent startup that goes into patent litigation becomes a patent enforcement company. It is a big red herring, a big distraction. You don't want to say, we don't have to worry about the competition because we have patents, because you can't afford to enforce them, right? It would change an investor doesn't want to invest in a patent enforcement company, they'd be doing that through private equity. But the investor wants to invest in a company that's going to be a unicorn and a great exit. So the patents are to make you more valuable. Don't count on them on protecting your market. Right? I'm going to go faster. Okay. Toronto, startup in tech. Jason. So it's okay if you're in Canada. Don't worry about it. Get to a certain stage. If you are starting to work with VCs, they'll tell you where they want you, right? Do they want you in Silicon Valley? Are you a company that's doing shipbuilding and you should be in Europe instead, or Japan or Taiwan or whatever? It really depends on where you are. I have Canadian clients. I have clients from all over the world, and there's an advantage to being in your home space. I wouldn't move automatically to Silicon Valley just to be part of Silicon Valley, unless you were joining an organization like Y Combinator, right, or Plug and Play, where they're going to put you through a program in a specific location. They will put you 4 to a room in bunk beds and have you stay in an apartment with 3 bedrooms and 12 people. No, I'm serious. I've seen this. And you can be a startup under some incubator. But for that reason, I'd move. Otherwise, I wouldn't. Not at this stage. Maybe your venture capital people will say, you really need to be, I mean, I have Ukrainian clients that are now spread all over the world because, right, they dispersed, right? So, all right. Oh, no offices in Toronto. Yeah, okay. We do have Canadian offices though. By filing, you mean provisional or not? By filing, yeah. Get something on file, do a provisional. Start with, right? It costs less. You got to make sure things work, raise money, and then do the non-provisional. Okay. Should I sign NDA when I ask? When I'm asked to. Signing an NDA or not depends a lot on your circumstances. I can't get into without knowing the details. Sometimes yes, sometimes no. It sounds like an attorney. Should I ask people to sign an NDA before I speak to them about my startup? Investors generally won't. They see too many deals. You know, a VC will see thousands of deals every year, and they can't possibly remember where. And a lot of them look a lot the same. Okay, literally, it's like, oh, I've seen this 3 years ago. I saw another company pitch exactly the same thing, right? So investors won't. Um, Partners like engineering firms might. You talk to your attorney. Yeah, it really depends. Is it easy to become a patent agent? It is. Um, okay, no, I'm gonna really, we're doing great, but yes. First of all, if you're coming out of college, look at the patent office. Its starting salary for government work, and government work in the last few months has become less desirable, but it's great. You'll spend some time getting trained, and then you can be living where you want. And there's a test to take. You have to have a certain educational background. I have a PhD, undergrad degrees in mathematics and chemistry. I have a PhD in analytical chemistry and chemical physics. You have to have a technical degree, and there's specific requirements. So sometimes people have to take some classes in order to meet those requirements, but then you can become a patent agent. It's fun. I encourage, I started practicing working for a law firm when I was 40. Okay. And it's been, um, no, no, younger than that, a little younger than that. I started in 2000. I'm not that old. Um, so I was young. I mean, I graduated from law school when I was 40. So, yeah, uh, it's fun. It's good. You get to work with great companies. Being an engineer, it was like the same project for like a year, but I do literally, I'm going to go and file after the seminar. I'm going to answer some desperate emails from clients. I'm going to file a AR/VR application for a very well-known company. And then I'm going to do work on an application that relates to a wearable device to detect cancer. Cool. I get to work with fun startups. Being a patent agent is good. So I became a patent agent, and the law firm that I was working for helped pay for law school. I went to a night school, which means I was working full time and then going to school in the evenings. It was 100 hours a week and torture, but it was a lot of fun. Yeah. Bill of hours is the ripoff. Why don't they charge us change? I charge for drafting by the page. Yeah, I like it better. You can do flat fee. A lot of firms do flat fee. I think my group, I'm the only people I've ever seen do it by page because it takes me about an hour per page. And so I don't have to count my time. I just count the pages when I'm done, right? And if I'm helping a kid with homework or if the cat's throwing up, right? It's not like, oh, am I charging? Do I turn the clock off? Clean up the pat? Yeah, never mind. I'm not telling you what attorneys charge you for, but yeah. I much prefer not charging by the hour. Chief lawyers influence elections for clients. Isn't that correct? No, it's lobbying, right? That's what attorneys do. They represent clients, and very often they're lobbyists. Yeah, most lobbyists are legal background. So, okay, we're done. I think I see there's more stuff in the webinar chat. I don't have time to look at that. This has been a great presentation. My email, is it still up there? No, it's gone. Okay. I'm easy to find. Connect with me on LinkedIn. Let me stop my recording. Yeah, pause. Boom. Bye.